Well, it is Monday, and I am back in the office after a very, very interesting weekend. Had a lot of traveling this weekend with my son for his hockey games throughout New Jersey. He had 4 games, and my daughter had a gymnastics competition. So it was a jam-packed weekend with us ending it with driving from North Jersey last night and getting home a little later than expected due to some traffic issues. But we're all back safe and sound. With that said, they come out with a blog article today regarding hearsay evidence. I was in court this morning in Gloucester County, New Jersey. I was in municipal court, in one of the municipal courts there, and we had a pretrial conference, really, of sorts. We haven't received discovery yet in the case, so not a lot going on. We're still doing Zoom in a lot of courts in municipal court in New Jersey. I personally believe that Zoom is here to stay in municipal courts in New Jersey. I think that even when, well, I think it is over, even when the shutdowns are over, I don't think the courts are going to go back to in-person appearances for a lot of things. I think a lot of statuses will be done via virtually to save on costs throughout New Jersey. I think it's actually a good idea to do that. I don't think there needs to be hundreds of people in a municipal courtroom, which is what you have a lot of times in municipal court throughout New Jersey. And I think it's a good idea to move toward virtual court for a lot of low-level offenses that can be handled very quickly in a Zoom type of court. We can't do that for Superior Court, but I think with municipal court, one of the good things that have come out of this shutdown is new technology that have shown us that we can do things to make things a little more cost effective for the state, which is always a good thing. With that said, that article that I came out on hearsay evidence and unavailable witnesses, we get this question a lot from our clients and their families. If a witness fails to appear for a trial or a preliminary hearing, does that mean the prosecution's case is over? And the quick answer is no, not normally. There are a number of ways the prosecution can develop a case without potentially a key witness, even in some cases, the alleged victim. There are situations, for instance, at a preliminary hearing. Remember that in Pennsylvania, preliminary hearings, hearsay evidence is admissible. It's not admissible at trial, but it is admissible at a preliminary hearing, provided the prosecution represents, and they always do, that the witness will be available for trial. If the witness is not available for trial, there are instances where there are hearsay exceptions to the hearsay rule. Now, in the case of a victim crime, I will tell you that in most cases, they do need the alleged victim, but there are a lot of other witnesses in a case that the prosecution can introduce evidence without necessarily calling the alleged observant of that allegation. There is non-testimonial evidence the prosecution can introduce. In addition, there are exceptions to the hearsay rule that I go into that article. Hearsay is a very, very complicated topic. We spend weeks on it in law school, and even then, people don't understand it. And having read probably hundreds of articles on it, and obviously gone to law school and been through those courses, having attended continuing education, I sometimes have to kind of check myself and make sure that I'm actually reading it correctly as to what would fall within an exception. So it's a very, very complicated issue. It's an issue that's been struggled with and will be struggled with forever. It will be the subject of many appeals and many pretrial motions and many post-trial motions. So keep that in the back of your mind. If you have questions, 215-755-9000 in Pennsylvania, 856-793-7429 in New Jersey, 24 hours a day, 7 days a week. Never assume that the case is going to go away or be dismissed because of a witness. You don't want to play that game. And I say game, but it's not a game. I can't tell you how many clients based against my recommendation have rejected, in some cases, very, very favorable plea offers and elected to, in some cases, move from our law firm because we've advised to accept the plea. And again, there are situations where you should accept the plea. And they've done it because they've told us, well, that witness is not coming to court. And in many situations, witness does come to court. And keep in the back of your mind, you cannot do anything to influence that person's decision to come to court. That is illegal. It is a very, very serious charge. It is witness intimidation. Courts take it very, very seriously. And if if you directly or indirectly encourage or discourage a person not to come to court, that is very, very serious. So above all, that's not something that you can involve yourself with if you're facing a criminal charge. Your attorney should be telling you that. It's the first thing they should tell you. But again, if you have questions, 215-755-9000 in Pennsylvania, 856-793-7429 in New Jersey, 24 hours a day, 7 days a week. The website, gamboandlaw.com. As always, a tremendous resource for you and your family. All of my books, my blogs, my videos are available there in one convenient format. It is a great website. We are very proud of it. It has all my downloadable, no-cost strategy books, and as well as my blogs, which I literally have hundreds of blogs on there, as well as over 250, I believe, videos, which has some incredible content. So once again, 215-755-9000 in Pennsylvania, 856-793-7429 in New Jersey, 24 hours a day, 7 days a week. Have a great Monday, and I'll talk to you all very soon.